to before the company can be able to issue out redeemable preference shares. Then the amounts to redeem the preference shares can only be gotten out of what we call distributable profits of the company, or maybe shares specifically issued for that particular specific purpose to redeem the preference shares. We said ordinary shares are the equity holders of the company. Equity holders of the company, they carry the main risk of the business of the company. They'll be paid as the last person. The holders will be paid as the last persons in case the company is actually to be liquidated. So the holders of these shares are actually able to control the affairs of the company in such a way that they are able to vote at the general meetings of the company and decide on matters concerning or touching on the company. So those were some of the characteristics we looked at with regard to these particular classes of shares. We said founders' shares are simply those shares that will be given to the promoters or the founders of the company. So the persons who found the company or formed the company are the ones who will be entitled to shares known as the founders' shares, the founders' shares. Employee shares, shares given to employees, maybe for good performance, or maybe to reward them for their performance or good work they have done. Any shares given to the employees, such shares will be termed as being employee shares. Bonus shares, so instead of getting dividends from the company, because at the end of the day, if you have shares in a company, the expectation at the end of the year or the end of the financial year is to get dividends, from the company. So you can simply be able to convert your dividends into more shares in the company. If you do such, we say you've gotten what we call bonus shares, or we can simply say capitalization of the dividends of the company. You capitalize them and they become part of the capital by simply not issuing them out to the shareholders, but of course asking them to acquire more shares in the company. Those shares they acquire or extra shares they acquire can be termed as being bonus shares, shares. So I want us to focus on maybe these particular areas. You see, we'll be able to complete them. Transfer of shares, transmission of shares, lien on shares, and mortgaging of shares, So we can start with mortgaging of shares. Let's start with mortgaging of shares. Mortgaging of shares. So what is mortgaging of shares? So when you talk about mortgaging of shares, here there are two parties that will be involved in the mortgaging of the shares. There are two parties that will be involved in the mortgaging of the shares. So we have the mortgagee, and number two, we have the mortgager. So mortgaging of shares is simply where a shareholder of a company uses his shares as a form of security to acquire a loan from a lending institution as a security. So they are assets. Shares are like assets, which can be used as a form of security, basically when you are getting a loan from a lender. So if such actually happens, we say the shares of the company have actually been mortgaged. So if you have shares of a particular worth of amount in a company, you can't be able to use them as a form of security from a lender, either a bank or maybe a SACCO as such. So if such actually happens, we say the shares have been mortgaged. So under mortgaging of shares, there are two parties. So the parties we have the mortgagee and you have the mortgager. The mortgagee is the lender in this case, and the mortgager is the borrower. The mortgager is the borrower. So what normally happens under this particular situation of mortgaging of shares, there are two ways of how mortgaging of shares can actually happen. So the first way, we call it legal mortgaging of shares. Number 2, we call it equitable mortgaging of shares. When you talk about legal mortgaging of shares, this is where a borrower, or basically a borrower of the amount, deposits with the register of companies a blank share transfer form, plus the share certificates of the shares that he has in the company. Then what will actually happen is the lender will fill out that particular share transfer form and of course transfer the shares into his or her name until when the borrower or the mortgage is able to dispense of or pay off the loan. That's when the shares will revert back to the borrower. So there's actually complete transfer of the shares to the lender as a security until when this particular borrower is actually able to dispense of or simply pay off the loan. That's when now the amount, or that's when now basically the shares can revert back to this particular owner or borrower of the amount. So under legal mortgaging, there are two parties. There's the legal mortgager and the legal mortgagee. The legal mortgagee will transfer the shares into his or her name until when this particular borrower is able to dispense of or pay off the loan. That's when the shares will revert back to the owner or the original borrower of this particular amounts from the lender. So you can actually be able to see that if you can remember very, very well, we said that one of the ways through which a person can become a member of a company is through what we call mortgaging of shares. So in this case, for example, under legal mortgaging, you can be able to realize that this lender will become a member of the company because the shares have completely been transferred to him as the lender. So until when this particular borrower is actually able to dispense of or pay off the loan, that's when the shares will revert back to the borrower. So a legal mortgagee actually becomes a member of the company, entitled to enjoy all the rights of a member of a company until when this particular borrower will actually be able to pay off or dispense off with the loan. So therefore, the legal mortgagee's name will actually be included in the register of members as a member of a company. That's why we said under membership that one of the ways through which a person can lose membership of a company is through what we call mortgaging of shares. So in this case, the borrower loses the shares until when he's actually able to pay off the loan. That's when basically he can be able to get back his or her shares. So that's what actually happens under legal mortgaging. So I've told you there is complete transfer of shares from the borrower to the lender. There is complete transfer of shares from the mortgager, who is actually the borrower, to the mortgagee, who is actually the lender, So what happens under equitable mortgaging of shares? So in this case, just from the word equal, there are equal chances or 50-50 chances. What actually happens here is that the borrower or the mortgager will simply deposit the blank transfer form for the shares with the borrower. Then once the lender has actually been able to get that particular form, he'll actually keep it or actually maintain it. And in case of default, that's when now he can actually be able to take a step to transfer the shares into his or her name. So you can be able to see, in this case, the borrower still remains a member of the company because at the initial stage of lending out the money, the shares are not completely transferred to the lender until maybe when this particular borrower actually defaults on the payment. That's when now he can be able to take a step and actually recover the shares from the borrower in the company. So we can be able to see that here we are saying that there is no complete transfer of shares to the lender until when he defaults. That's when now the lender can be able to take an action to be able to recover the shares completely from the borrower. So under legal mortgaging, there's complete transfer of shares to the lender until when the loan is actually cleared. That's when the shares will revert back to the owner. Under equitable mortgaging, the borrower still remains a member of the company, entitled to enjoy the rights of a member of a company, unless he defaults. That's when now the lender can be able to take a step, fill out that particular form, and actually be able to recover his or her amounts from the company, from the company in terms of being represented by the shares of the company, of the shares of the borrower in the company. So those are the two ways through which mortgaging of shares can actually be able to happen. So you have what we call legal mortgaging. There's complete transfer of shares to the lender until when the borrower is able to pay off the loan, that's when now the shares will go back to the borrower or will be taken up back by the borrower of the loan. Under equitable mortgaging, there is no complete transfer of the shares unless maybe the borrower defaults on payment of the loan. That's when now the lender can be able to take a step and recover the shares from the borrower in the company. So this one is usually very risky to the lender, because what can actually happen, for example, if this lender has not notified the company that the shares shouldn't be dealt with in any way unless he is actually informed, because they have been used as a form of security. What can actually happen if you have unscrupulous borrowers, they can be able to end up selling the shares without the knowledge of the lender, because the shares are not completely transferred to the lender. They are still in the name of the borrower. So if the company has no notice or is not actually notified of these shares having been used as a form of security, then they can be dealt with by the borrowers by simply being able to sell to a third party or another person, such that when the lender takes a step to recover the shares from the borrower in the company, he might find that the shares have already been transferred to another party. So equitable mortgaging is usually very risky for the lender, such that, for example, that one can actually be able to happen, the shares being transferred without the knowledge of the lender. So to avoid such kind of risks, some of the measures that can be taken by the lender is, for example, number one, to send out what we call a notice in distrangers. A notice in distrangers, just to notify, it's simply just a notice to notify the company that the shares shouldn't be dealt with in any way without the knowledge of the lender. They shouldn't even be sold by the borrower without the knowledge of the lender. So he has to be notified if the shares are being dealt with in any way. Another way is to transfer the shares immediately. So immediately transfer the shares into his or her name as the lender. So transfer the shares immediately. Basically, when he gets the share transfer form and the share certificate, take the necessary steps to ensure that he transfers the shares into his or her name immediately when the money is being lent out to the borrower or the mortgager. So in such a case, the question of equitable mortgaging won't actually arise. Is, for example, just like immediately converting this particular form of arrangement from being equitable to becoming legal mortgage. So transfer the shares immediately into his or her name when the loan is to be lent out, or when they enter into an agreement with the mortgager immediately. So the question of a default won't actually arise, and therefore he'll be entitled to the shares of the company in case there is actually any default. So those are the two ways through which mortgaging of shares can actually happen. So we have legal mortgaging, and we have what we call equitable mortgaging, and we have what we call equitable mortgaging. So I want us to look at transfer of shares. I don't know if we had looked at it. Transfer of shares. So we can look at transfer of shares. So we can look at transfer of shares. So under transfer of shares, there are two ways. There is partial transfer of shares, and there is full transfer of shares. So what is important here is for you to be able to know that there are usually two parties. There's usually the transferor of the shares, and there is the transferee. So So there's the transfer of the shares and there's the transfer. Then the instrument involved in the transfer of shares is actually known as a share. There's usually a share transfer form. So this is simply the agreement that forms that particular agreement of transfer of shares between the transferor and the transferee. So the transferor is basically the one transferring the shares from his or her name and actually transferring them to the transferee, the one who now receives the shares. So what normally happens is, for example, if it is full transfer, you can start with full transfer of shares. If it is full transfer of shares, the share transfer form will be filled out by the two parties, of course, by indicating their name and address, the number of shares being transferred, the consideration being paid or the amount of money being paid for the shares. Then, of course, at the end of it all, they'll be able to sign, both of them, the transferee and the transferor, they'll indicate their signature on the share transfer form. Once they have indicated their signature there, this particular share transfer form, together with the certificate, the share certificate, will be presented to the company. It will be presented to the company. So, for example, in this case, if the transferor was having 1,000 shares in the company, because it is full transfer of shares, it simply means that he's transferring all her shares. So if it is 1,000 shares, they'll indicate clearly on the share transfer form that the shares being transferred are actually 1,000 shares. So this particular instrument or share transfer instrument will be received by an officer of the company, an officer of the company. It could be the company secretary, it could be the company secretary, or any other officer authorized to carry out such a mandate. Once it has been presented to the company, so this particular officer will clearly indicate that he has been able to receive this particular documentation, that is the share transfer form and the share certificate. It will be presented to the board of directors for the approval of the transfer of the shares. So once it has been approved, what will happen now, the previous share certificate, which was indicating the name of the transferor, will be cancelled out, and of course the company will issue out a new share certificate indicating that the shares have been transferred to the transferee. Now the transferee will get a share certificate from the company indicating the number of shares he has acquired, in this case, for example, 1,000 shares, while the previous share certificate belonging to the transferor will be cancelled out. It will be cancelled out, and of course now in this case the transferor will lose membership, and therefore his or her name will be removed from the register of members, while that of the transferee, the one receiving the shares, will now be included in the register of members. So that is what will actually happen under what we call full transfer of shares. There is completely transfer of all the shares from the transferor to the transferee. What normally happens, the key thing is that there must be a share transfer instrument. That share transfer instrument, we are saying, is the share transfer form. This share transfer form is the one that actually forms the agreement between the transferor and the transferee, such that it is filled out by these particular two parties, clearly indicating, for example, the name or address of the company, that is where the transaction is actually happening, the name of the transferor, the name of the transferee and their addresses, the number of shares actually being transferred, consideration being paid for the shares. Then, of course, at the tail end of it all, it will actually be signed by the transferor and the transferee. Once that instrument has been filled out properly, it will be presented to the company. It will be received by an officer of the company who will clearly indicate or certificate that he has been able to receive that particular documentation for the transfer of the shares. Once received, it will be presented to the board of directors for the approval of the transfer of the shares. So if it is actually approved, then of course you are saying the previous share certificate that was actually be indicating the name of the transferor will be cancelled out, and they'll give out a new share certificate, clearly indicating that the transferee, the one receiving the shares, has acquired the shares of the company. What happens at the end of it all? The name of the transferor will actually now be removed from the register of members, while that of the transferee will now be included in the register of members. That's why we said transfer of shares is actually one of the ways through which you can either lose or gain membership of the company. So you can be able to see the transferee is gaining membership while the transferor is losing membership. So that is what actually happens, for example, if you transfer all the shares. What will happen, for example, if you transfer, let's say, for example, You have 1,000 shares, but you only transfer 500. So that is what we are calling partial transfer. You don't completely transfer your shares. You transfer part of the shares. What should actually just come to your mind, quite obviously, both parties will remain as members of the company at the tail end. That is what will actually happen. That is where basically where the major difference comes in. At the tail end of it, of the transfer process, both parties will still remain as members of the company because the shares have not been completely transferred. They have not transferred all the shares of the transfer. They are transferred just part of it. So for example, in this case, if they transfer 500 out of 1,000, it simply means that the 500 will go to the transfer while the transfer will remain with the other 500. So both of them will still actually be recognized as being members of the company. So what happens in this case, for example, if it is actually partial transfer of shares, what will happen in this case? I've told you the key thing. There's a transfer instrument. There's the share transfer form. It must be filled out by both parties. Now, in this case, it will be presented to the company either by the transferee or maybe a stockbroker, basically a person who is facilitating the transfer of the shares. So once it has been presented to the company, it will be received by an officer of the company. What will happen now, this is where now the difference comes in. So the officer of the company will simply indicate on the shares certificate the number of shares being transferred to. So on the share certificate, the number of shares being transferred to the transferee, that is 500. And of course, actually prepare also a balance, what we call a balance ticket. Balance ticket. Just a documentation clearly indicating the number of shares remaining with the transferor. So the certificated share certificate will be given to the transferee as a clear evidence to claim for the shares from the company, while the balance ticket will indicate the number of shares remaining with the transferor. So this one will be given to the transferor. He can't be able to use it as a claim for his or her shares in the company. So once that has actually happened, this particular proposal or proposed transfer of shares will be presented to the board of directors. Once they approve, what will happen? The previous share certificates will be cancelled out, and of course now the company will give out 2 new share certificates. While 2 new share certificates, we've said the transferor does not lose membership of the company. He will still remain as a member because he has just transferred part of his or her shares, not all the shares. So 2 new share certificates will clearly be prepared, and one will be given to the transferor indicating the number of shares he has remained with, while the other one will be given to the transferee indicating the number of shares this transferee has acquired in the company. So both parties will still now remain members of the company. The transferor won't lose membership of the company, but of course what will actually change is the number of shares that he or she actually holds in the company. He or she actually holds in the company. So that's basically what will actually happen under partial and full transfer of shares and full transfer of shares. So that is what we mean by transfer of shares, and that is what will actually happen. So I want us to look at lien on shares, lien on shares, lien on shares. So what is lien on shares? Lien on shares. So lien on shares. So this is simply the right of the company to be able to withhold the shares of a shareholder of a company. For example, if this shareholder is actually indebted to the company. So we were giving an example, I think last time we talked about Regina, that Regina has a very big bar and restaurant in town. So Regina is actually also a shareholder in a company known as EABL. So Regina is a shareholder in a company known as EABL. Regina also owns a very big and bar restaurant in town. So Regina has actually been getting her supplies from East African Breweries Limited on credit. Remember, we've said initially Regina is actually also a shareholder at East African Breweries Limited. But due to the COVID pandemic, this particular bar and restaurant business has not actually been performing so well. So Regina hasn't been actually been able to pay off her due amount to EABL. If the articles of association of East African Breweries Limited actually allow, what they can actually be able to do, they can exercise what we call the right of lien on the shares of Regina. So they can simply withhold the shares such that Regina won't actually be able to deal in the shares in any way until when Regina is actually able to dispense of or pay off the due amount to EABL for the supplies made to her. That's when now the shares can be given or be released to Regina. So if EABL exercises that particular right, we say they are exercising a right known as the right of lien on the shares of Regina. Remember what have we said? We've said Regina, the first key thing, Regina is a shareholder at EABL. Regina operates a very big and bar restaurant in town. So Regina gets her supplies on credit from EABL. But of course, due to the pandemic, this business has not actually been performing so well. So she has been struggling to pay off the amounts or these particular supplies that were made on credit to her by EABL. So if EABL has the right to exercise the right of lien on her shares, what they can simply be able to do is to withhold the shares of Regina in the company until when Regina is actually able to pay off the due amounts. That's when the shares can be released to Regina. If she fails to do so, then of course the company will take over the shares. They can simply be able to sell them to another person. But you've said the key thing, the articles of association of the company must actually be able to allow for this particular right. So it must be contained in the articles of association of East African Breweries Limited. Simply the rules governing the internal affairs must actually clearly indicate the company can be able to exercise what we call the right of lien on the shares of the members of the company. That is what we mean by lien on shares, the right by the company to be able to withhold the shares of a shareholder if this particular shareholder is actually indebted to the company, So if there's one key thing to be able to note, if these particular shares have actually been mortgaged, the mortgagee will be given the first right over the shares. Two things have actually happened with regard to those particular shares. The company can be able to exercise the right of lien. But on the other hand, these shares, I've already just discussed what is mortgaging of shares. These shares have actually also been used by Regina to get a loan in the bank. Regina has actually been able to present the share certificate for EABL in a bank to acquire a loan. So if it actually happens that she actually defaults on payment of her due amount also to EABL, the mortgagee in this case, the lender in this case, will be given first priority over the shares, such that this mortgagee will be entitled to exercise the right under the mortgaging of shares before the right of lien can be exercised. What do I mean? A legal mortgagee, or basically a mortgagee in this case, will be given the first right over the shares, over what we call the right of lien on the shares by the company. So if Regina has used her shares also to get a loan from a lender or maybe a bank, that particular bank will be given priority. It will rank number one to acquire the rights over the shares before the company can exercise the right of lien on the shares. So sometimes they could test in the exam and they mix the two concepts. They simply want you to be able to know whether you understand that mortgaging of shares will be given priority over lien on shares. So the lender in this case of the due amounts to Regina will be given first priority. He will be the one to be able to take over the shares first before the company can be able to exercise the right of lien on the shares of the company, So that is what we mean by lien on shares. Lien on shares. So we can briefly look at transmission of shares. So transmission of shares basically will happen in circumstances whereby, for example, there is what we call death, insanity, or bankruptcy. bankruptcy of member of a company or bankruptcy of a member of a company. So in case of death, insanity, in case of death, insanity, or bankruptcy of a member, in case of death, insanity, or bankruptcy of a member. So the shares will be transmitted or will be transferred. So that particular process of transferring the shares from the person who has actually passed on, from a person who is actually insane or a bankrupt person, is what we call transmission. So the shares can be transmitted or be transferred to the beneficiary. It can be the beneficiary, trustee, or maybe the receiver. So the receiver will actually be in the case of bankruptcy. So when you talk about a person being declared to be bankrupt, it simply means that this person is not actually able to meet or pay off his due amounts to other parties. So they can be able to go to court, and this person is actually declared bankrupt. So if he's declared bankrupt, the shares, being part of the asset that he actually owns, will be taken over by a receiver on behalf of the lenders of to this particular person. So in case of death, there's usually the beneficiary. There could be a will. So this particular will, maybe it can be taken over by the administrator, who can present to the company, and the shares are taken over by the beneficiary who has been stated in that particular will as the one who will take over the shares. When you talk about a trustee, simply a person who can be able to hold property on behalf of another person. So sometimes some of the shares can be taken up by the trustee to hold them on behalf of the owner of the shares, on behalf of the owner of the shares. Maybe in this case, the beneficiaries have not attained the age of majority, so they can be taken over by the trustee to hold brief for them until when they attain the age of the majority. That's when they can be able to take over the shares. So that's what we mean by transmission of shares. So the key thing here is the administrator of the will should actually be able to present to the company and clearly indicate how the shares should be dealt with in terms of actually being transmitted to the beneficiary, of the shares. So I want us to look at a particular question. It will be of much help. It will be of much help as to what we've just learned in today's class. So let me look for it and actually share. So you can look at that question I've just shared, question 2. You can look at it for like a minute, just for a minute. Look at it. Look at that particular question 2A, what it says, question 2A, what it says. So I think we can look at that particular question. It says Kamau borrowed 50,000 shillings. Kamau borrowed 50,000 shillings from Hope Bank and deposited his XYZ Limited share certificate with a blank transfer as a security. So subsequently, he bought goods from the supermarkets on credit worth 15,000. The articles of XYZ Limited claimed a first and paramount lien on its members' shares on debt due to the supermarket. However, before the supermarket's lien arose, the bank gave the supermarket notice of Kamau's share certificates having been lodged with the bank as security for the loan. Kamau is unable to pay the goods he obtained from the supermarket and has also defaulted on the loan. XYZ Supermarket wants to exercise its lien and the bank wants to exercise its equitable right to have the shares transferred into its name. Analyze the rights of the bank. Number 2, XYZ Supermarket Limited. You can be able to see that there are two aspects coming out here. There's what we call the right of lien on the shares of the supermarket and also what we call mortgaging of shares. So the supermarket in this case has a right of lien on the shares of this person known as Kamau. Also, he has used the shares as a security to get a loan from the bank. So what are the rights? Analyze the rights of the bank, analyze the rights of the bank, analyze the rights of the bank. So you can simply be able to say that maybe you can write the answer. You can write the answer to this particular question. You can write the answer to this particular question. The rights of the bank. The rights of the bank. You can simply be able to say the bank is a mortgagee. The bank is a mortgagee. The bank is a mortgagee. The bank is a mortgagee of the shares of Kamau, simply say of Kamau's shares, in XYZ Limited, of Kamau's shares in XYZ Limited, in XYZ Limited, in XYZ Limited, full stop. In XYZ Limited, full stop. You can simply be able to say the bank had notified XYZ Limited. The bank had notified XYZ Limited. XYZ Limited of the shares, had notified XYZ Limited of the shares having been used as a security, having been used as a security for an amount of 50,000 shillings, for an amount of 50,000 shillings, lent to Kamau, for an amount of 50,000 shillings, lent to Kamau. Then you simply say, since Kamau has defaulted, on the payment, the bank will be given priority. Over XYZ Limited, the bank will be given priority over XYZ Limited. Will be given priority over XYZ Limited. Over XYZ Limited to take over the shares, 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 to take over the shares. To take over the shares. To take over the shares. Then XYZ Limited, XYZ Limited, XYZ Supermarket Limited rights. XYZ Supermarket Limited, Supermarket Limited rights. You can simply be able to say the articles of association, the articles of association of XYZ Limited, the articles of association of XYZ Limited provide for the right of lien, provide for the right of lien on the shares of the members of the company, provide for the right of lien on the shares of the members of the company, on the shares of the members of the company, provide for the right of lien on the shares of the members of the company. Full stop, then you just say, even though the company can exercise these rights, even though the company can exercise these rights of lien, even though the company can exercise these rights of lien, comma, it won't be given priority, it won't be given priority, it won't be given priority, it won't be given priority over the equitable rights, over the equitable rights, over the equitable rights, over the equitable rights, equitable right to Hope Bank Limited, to Hope Bank Limited, equitable right to Hope Bank Limited, to Hope Bank Limited, to Hope Bank Limited, to Hope Bank Limited. To Hope Bank Limited. Full stop, then you just say the equitable right arose, the equitable right arose as a result of, the equitable right arose as a result of, the equitable right arose as a result of Kamau having used his shares, Kamau having used his shares as a security, Kamau having used his shares as security for a loan, as a security for a loan from Hope Bank Limited, as a security for a loan from Hope Bank Limited, as a security for a loan from Hope Bank Limited. full stop, then we just say XYZ Limited, XYZ Limited can use other means, to recover, the due amounts, from Kamau. XYZ Limited can use other means to recover the due amounts from Kamau, or until he pays off the loan, to Hope Bank Limited, That's when, until he pays off the loan to Hope Bank Limited, that is when the company can exercise the right of lien. Over Kamau's shares. Can exercise the right of lien over Kamau's shares. Over Kamau's shares. So that's how you can be able to answer that particular question. So maybe we can look at something small about transfer of shares, which we are going to wind up this particular class of ours today. So I want us to look at what we call a forged transfer of shares. A forged transfer of shares. So when you talk about a forged transfer of shares, this is simply where, because I've told you under transfer of shares, there is the key instrument that is used to transfer the shares. That is the share transfer form. So on this share transfer form, because I've told you there'll be the signature of the transferor and the transferee. So if it actually happens that the signature of the transferor, for example, is actually forged to enable the shares to be transferred, maybe a person with bad intentions actually forges the signature of the transferor and actually and uses it to be able to transfer the shares to another person. In such a case, we say what has actually happened is a forged transfer of shares, whereby the transfer of shares happens in a situation whereby the signature of the transferor is forged on the transfer form. That particular kind of a transfer of shares, we call it a forged transfer of shares. So what you normally say is that any forged transfer of shares is actually null and void, and it will never pass title. So for example, if we have two parties, A and B, so the shares were actually transferred to party B out of or as a result of a forged transfer of the signature, on the share transfer form. So that particular kind of a transfer, we'll call it a forged transfer. So it is actually null and void. It will never pass title to the transferee. It won't pass title to the transferee. The transferor is entitled to get his or her shares back in the company. So if there are any damages actually lost, the person who actually procured this particular transfer of shares is the one who will actually incur all the costs and damages incurred as a result of the forged transfer of shares. So what is the key point here? The key point here is for you to be able to know that any forged transfer of shares is usually null and void. It will never pass title to the transferee. The original owner of the shares, the transferor, is the rightful owner of the shares and therefore is entitled to get back his or her shares. Sometimes it could happen in this particular situation whereby the shares are actually forged and actually transferred to B. The share transfer form is forged and the shares are transferred to B. And of course, further on, the shares are transferred to another party. Will this particular original owner be entitled to the shares? Yes, he will be entitled to the shares because you've said any forged transfer of shares, it doesn't actually matter whether even if this particular person acquired the shares innocently in the company or maybe in the open market, but originally these shares, the ways they have actually moved from the original owner is through what we call a forged transfer of shares. Party C won't be entitled to the shares because we are saying any forged transfer of shares is actually null and void and it will never pass a title. So what will happen, for example, in this case, you can be able to see that, for example, if this particular party innocently bought the shares in the open market, but originally they were actually transferred to party B through what we call a forged transfer, is going to suffer losses or damages. For example, the money spent to acquire these particular shares, because you are saying it will never pass title. The shares will be entitled to the original owner of the shares, even if you bought them innocently from the company without the knowledge that originally these particular shares were actually transferred as a result of a forged transfer of the shares. So you as a third party in this case, you would have actually incurred losses or damages as a result of buying the shares in the open market. So how will you recover your damages? The damages can be recovered from the company where you acquired the shares. But of course, now what will happen with the company? The company will go ahead and actually recover those particular losses or damages paid to party C from the person who initially procured the transfer of the shares. Maybe it could be a stockbroker who forged the signature of the transferor and originally transferred the shares. So the company is going to incur for all the damages or costs incurred to party C to acquire the shares. But of course, they'll now go ahead and actually recover those particular losses or costs they pay to party C from the person who originally procured the transfer of the shares or the forged transfer of the shares. So you are saying a forged transfer of shares is whereby the signature of the transferor on the share transfer form is actually forged, and this basically leads to the transfer of the shares to the transferee in this case. So we are saying any forged transfer of shares is null and void. It won't actually pass title. The original owner of the shares is actually entitled to the shares. Even if they have been acquired by a third party, that third party, even if he bought the shares innocently, but it can actually clearly be found out that originally the shares were transferred as a result of a forged transfer. The original owner of the shares, the transferor, is actually the one who has the rightful entitlement to the shares, but not actually the third party. You can see the third party is incurring losses or damages for having bought the shares innocently. So those particular losses or damages, we are saying they'll be paid for by the company. But of course, the company will go for the person who initially procured the forged transfer of the shares. So that's what you need to be able to know about the forged transfer of shares. It is actually null and void. It will never pass title. So what the examiner normally does, he'll bring a scenario. He'll say, for example, let's say, for example, James actually acquired shares in a particular company. These shares were actually transferred maybe to Sam, like that. So it is discovered that maybe there was a forged transfer. So you must be able to realize very fast that the original owner of the shares is the one who has the entitlement to the shares. It doesn't matter whether even if party C acquired the shares innocently without the knowledge that these particular shares were actually transferred through what we call a forged transfer of shares. Those losses incurred by party C will be paid by the company, and the company will go for the person who initially procured that particular forged transfer of shares in the company. So that's basically what you need to be able to know about what we are calling a forged transfer of shares. A forged transfer of shares. A forged transfer of shares. So I think you don't have the notes for these particular parts that I've just taught today. I think I'm going to share them. I'm going to share them immediately after this particular class so that you can be able to capture from this. But I think this particular point you don't have the notes. So I'm just going to share them so that you can be able to have them for your own personal studies. But I think next time I think it's tomorrow. It is tomorrow. I think tomorrow we'll wind up briefly on this particular topic, just something small about, I'll see if it is possible I tackle it tomorrow. If I don't tackle it, we'll do it later. Is the transfer of shares through what we call the central depository system. So you'll be able to see what is a central depository system. It is simply basically a system whereby you can be able to hold your shares electronically. So the same way you carry your money through M-Pesa, you can transfer to another person like that, like that, like that. So the same way shares can be held electronically in a system known as the central depository system. So that is the last bit of this particular topic. It is known as transfer of shares under the central depository system. So we'll discover more what is a central depository system. We'll see that you must have an account with in this particular system before your shares can be held electronically. What are the advantages? For example, if you hold your shares electronically in the CDS, so the most obvious advantage is that it does away with paperwork. For example, what we've seen under manual transfer of shares, you can see you fill out a share transfer form, you present to the company, you do a lot of documentation. But of course, if the shares are held electronically, it does away with a lot of paperwork, so you can just easily transfer your shares, maybe through your phone, or maybe through a tap of your phone. You can be able to transfer the shares to another person. So it can be able to hold shares. Apart from shares, also bonds or government bonds or corporate bonds can actually be held under the central depository system, and the customer, or basically the client, can be able to transfer them electronically to any other person or party. So that is basically what we look at, and then of course start looking at the topic of share capital, which is topic number 5, So I don't know if there is any question at this particular point. You can be able to ask a question or maybe raise any concern before we say it is the end of the class. So I don't know if you have a question or you guys are okay. I can give you like a minute. If you have a question, you can maybe unmute and just raise the question so that we address it. It seems you guys are quite okay. So I think we'll meet tomorrow. We start the topic of share capital.